Large jury verdicts, large settlements of personal injury cases. Hey, how does that happen? Well, one, it happens if there has been a very bad injury and liability. Two, it happens, well, if there's been tampering of the evidence. So let's take a look at this week's case. It involves a real man, real accident took place in King of Prussia, Pennsylvania. And there we had a man, he was a salesman, Dennis Dimwicki, and he was visiting a manufacturing site, First Quality Enterprises. And when he went into the reception area, he slipped on some water and suffered a pretty bad injury. He suffered a concussion, he suffered damage to his spine, and he underwent about $300,000 in medical treatment, and it was anticipated that he would need to have another $1 million worth of medical care in order to fully deal with the injuries. Okay, so bad injuries. The case went to trial. And it settled after 6 days of trial. It was not a case that went to a verdict. It was a case that settled during the trial. And the reason it settled was that the evidence was not coming in well for First Quality Enterprises. Evidence was coming in very badly for them. Among the things that happened is that it was demonstrated that the safety manager for the company had actually tried to hide some of the evidence. One of the things that happened is that the water wound up in the reception area because of a watering pot that was used to water plants in the area. The safety manager, according to some of the evidence, appeared to try and hide that watering vase, that watering pot. And in addition, while there was a video surveillance camera in the area, when the videotape was produced during the discovery before trial, it appeared that the videotape had been altered, had been tampered with. And when the plaintiff asked, as the plaintiff has a right to do, to see a copy of the original videotape and to see the equipment upon which it was originally produced, well, the guys on the other side said, we don't own it anymore. So they never were able to produce it. So the evidence kept coming in indicating that the safety manager and others there at First Quality Enterprises were trying to cover up the evidence. And faced with that, the jury wasn't happy. Now, we don't know what kind of an award the jury would have made, but we do know that people were carefully watching the jury, and sometimes you can get some pretty decent messages as to how a jury is going to go by how they're behaving. And observing that, the party said, "Ooh, this isn't going well for First Quality Enterprises, and therefore we think we're going to settle," and they agreed to settle for roughly $6 million. So this is an example of how a case can go badly for someone when they attempt to cover up the evidence, when they attempt to hide evidence. Under our civil jury approach, when you have a case that is going to trial, it's really a case that has been pretty well examined before it ever goes to trial, because each party, the plaintiff bringing the case, the defendant, have a right to ask questions, to get evidence, to find out what the other side has, and there is generally a pretty good understanding of what is going to be taking place at trial. And if it appears that somebody has been trying to tamper with the evidence, guess what? Generally, a jury does not like that at all, and things go very badly. I'm David Allen, and we bring you this case. We bring cases every week so you understand how the law works.